This guy doesn't answer questions.
I don't answer questions.
He doesn't answer questions.
I don't answer questions.
They're recording on their cell phones right now. You're over here with a firearm flashing right at me.
Welcome back to the LackLuster channel. Today we're looking into a traffic stop initiated by the Arapahoe County Sheriff's Office, where Deputy Hackler pulled over the real constitutional upholders and would allege that he was speeding. The video begins as Deputy Hackler places his phone call on hold.
I'll be right back.
Okay, 46.
A moment later, he is at TRCU's window.
Good evening. I'm Deputy Hackler with the Arapahoe County Sheriff's Office. The reason I was pulling you over is you were going a little fast down there on Arapahoe Road. It's 45 and you're going way fast.
Okay.
Do you know how fast you were going?
I don't answer questions.
You don't answer questions?
No. Here's my registration, license, and I'm pulling up my insurance right now.
Okay, perfect.
1 second.
Well, I had to do 103 to catch up to you from Piccadilly and all the way up to Buckley's before I even caught up to you.
Did you clock me on radar? Or?
No.
Oh, so you didn't clock me?
No.
You just caught up to me?
Mm-hmm.
Okay, I understand.
Visually, I estimated your speed around like 65. Okay.
Colorado does allow its deputies to issue speeding tickets based on their personal observation alone. However, without the use of speed measurement devices and relying solely on the deputy's claim that he sped 2.5 times over the speed limit in the absence of an emergency to catch another driver, it would be very difficult for the officer to prove the violation in court. We'll touch on that more later, but for now, Deputy Hackler continues to ask questions and TRCU continues to refuse answering.
I don't answer questions.
Okay.
Is that without insurance good?
Oh, can you pull it up again?
After verifying the insurance, Hackler returns to his phone call, where his frustration with constitutional rights becomes apparent.
This guy doesn't answer questions.
At all?
Well, that's what he says. I asked him if he knew how fast he was going because I had to do over 100 to catch up to him. And he says, I don't answer questions.
Well, that's nice.
Mm-hmm. And then he's driving a car that's not his. And I asked him who this person is, and he says, I don't answer questions.
This could get interesting.
It's very interesting, and a moment later, Deputy Mitchell Bramblett arrives on scene.
What's up, dude? All I was doing is flying past. I was heading eastbound, he was heading westbound. Flipped around, and I was almost to Liverpool, like Piccadilly area. So I turn around, try to catch up to him. I'm like doing like 106, trying to catch up to him. I don't catch up to him till like Buckley, and he's like weaving around traffic and shit.
Oh shit.
So I'm gonna get him for speeding and reckless. He doesn't answer questions, by the way.
What?
He doesn't answer questions. He's driving somebody else's car, but he won't tell me who that person is.
During their chat, Deputy Hackler notifies Bramblett that the passenger is recording. Why becomes apparent soon.
They're recording on their cell phones right now.
Huh?
They're recording on their cell phones right now. So you know.
Which one, the driver?
Huh?
Which one's recording?
The one in the passenger seat. Here's your documents back.
Okay.
All right, like I said, I visually estimated you at 65 and a 45.
You visually estimated me?
Yeah, when I was going westbound, or eastbound, you were going westbound, you flew past me.
And you didn't clock me with any sort of radar or any sort of
it was visual, but you were definitely going
When is
too
the last
fast.
time that your eyes have been calibrated?
It doesn't matter about my eyes.
TRCU displayed US v. Sowards on screen, and the text is correct. The court held that law enforcement must rely on more than their subjective judgment in situations where precise measurements like speed are at issue. The court stressed that using reasonable suspicion to circumvent the Fourth Amendment requires more concrete evidence, especially in cases like a speeding violation. However, it's important to note that the case was a decision by the Fourth Circuit, and its ruling is not binding on courts in Colorado, as it is located within the 10th Circuit. Cases from outside a particular jurisdiction can be cited as persuasive authority, meaning that while a Colorado court is not required to follow the ruling in US v. Sowards, it can consider the reasoning of that decision if the circumstances are similar. But more interestingly, in a previous episode we dissected the 10th Circuit Court of Appeals case Irizarry V. Yehia. This case was not only decided in the same circuit and state, in fact, the Irizarry case occurred in the neighboring county. During the incident that sparked that case, Eric Brandt and Liberty Freak TV were observing a DUI investigation when Officer Yehia arrived on scene and stood directly in front of Liberty Freak's camera.
Hey, get the f*** out of his face, asshole! Get the f*** out of my lawn. What's wrong with you?
A moment later, he would use his flashlight to prevent Eric Brandt's camera from recording the scene.
What are you, a clown? Oh, it's gotta be one f***ing jack to f*** the whole thing up. What the f*** is wrong with you people?
The men attempted to file a complaint with the supervisor on scene, but were met with closed ears, so Mr. Irizarry sued Officer Yehia pro se under 42 U.S. Code 1983, alleging that the officer violated his First Amendment rights. The district court dismissed the complaint for failure to state a claim, finding that Mr. Irizarry had alleged a constitutional violation, but held that Officer Yehia was entitled to qualified immunity because the violation was not one of clearly established law. Liberty Freak appealed, and the University of Colorado School of Law, the Electronic Frontier Foundation, the Cato Institute, the National Police Accountability Project, and the First Amendment scholars filed amicus briefs on behalf of Liberty Freak. Finally, on July 11th of 2022, the 10th Circuit Court of Appeals reviewed the district court's opinion and the allegations that Officer Yehia intentionally positioned himself directly in front of Mr. Irizarry to make sure he intentionally obstructed the camera view and attempted to saturate Eric's camera sensors by shining an extremely bright flashlight at it, and that Officer Yehia's actions amounted to a blatant plier restraint, and Officer Yehia deprived him of his rights to freedom of the press and sought to punish Mr. Irizarry for exercising his rights. Upon reviewing the district court's decision, the 10th Circuit Court reversed, revoking Officer Yehia's qualified immunity because of the many sibling circuit court decisions that recognized the right to film the police.
What's your name? Yehia.
Now with the ruling in Irizarry v. Yehia in the 10th Circuit, if TRCU were to pursue civil action on this case, Deputy Bramblett would almost certainly lose his qualified immunity, and a door would be open for TRCU to argue against the officer's ability to pull a person over without radar, LiDAR, or pacing in the 10th Circuit.
You flew past me.
And you didn't clock me with any sort of radar or any sort of
it was visual, but you were definitely going
When is
too
the last
fast.
time that your eyes have been calibrated?
It doesn't matter about my eyes.
Okay.
I've been trained.
You've been trained?
Yeah.
Okay.
To visually estimate.
I'm gonna go to court for this.
That's fine.
I'll fight it.
So I'm citing you for speeding 20 plus in a 45. Okay. And reckless driving because there was other cars that you're driving past, weaving in and around traffic.
Weaving in and around the traffic.
Yep.
Okay. I have a dash cam, by the way.
That's fine.
That records my speed.
So you should have seen that other car that you cut off right before you went to the light when I finally caught up to you.
I didn't cut them off. I had plenty of space.
Okay, that's fine. Either way, your court date is going to be Monday, October 7th, 2024 at 2 p.m. I will be there.
For sure.
Arapahoe County Combined Court. It's down there. There's the address right there. All right. I just need a signature from you right here saying that you'll show up to court.
Not an admission of guilt?
Nope.
No problem. Right here?
Yep.
There's my signature autograph. There
Perfect.
You
Here's your citation.
go. No problem. And
Drive
can I get
safe.
your business card?
My name's on there.
I can't get your business card. Can I get yours, sir?
Drive safe. All my information is on my...
I want your business card. It's professional for you to just give me your business card. Is that too much to ask for? The stop's over, so can I just get your business card? That's all I want.
Why are you getting out of your vehicle right now?
Huh? I didn't hear what you said.
You need to step back in your vehicle.
The traffic stop's over.
Correct.
So can I get your business card?
And you're over here with a firearm flashing right at me.
I'm open.
Get back in.
Is open carry illegal? It's not.
Get back in your car.
Or else what?
Have a good day.
I need your business card.
My information is on the citation that I gave you.
Business card. Because I'm gonna request all this, the video evidence for your body cams, and I want to request all this information.
Okay. You can get all that.
My lawyer. I want your business card.
Hey, there you go.
I appreciate it. Thank you.
Have a nice day.
I appreciate it. That's all you had to do. Can I get yours?
Literally, all his badge
No,
number.
I understand that, but I like the business card just so I can give it to my lawyer. It's not the first time I've been to this. Don't be scared of firearms, bro. It's the Second Amendment.
I'm not afraid of firearms.
I see your memorial band.
Yeah.
Marine Corps.
Marine Corps.
Thank you for your service. That's all you had to do.
Okay. Have a good day. Drive safe.
Traffic stop's over. I'm free to go, right?
Go. Yeah. Go.
As stated on screen earlier, the citation was never submitted to the courts. My guess as to the reasoning why is as good as yours. But while researching this incident, I found a social media post by Deputy Hackler featuring the iconic Guy Fawkes mask and phrase from the film V for Vendetta. This alone exposes his blatant irony. A law enforcement officer, publicly aligning himself with a film that stands as a clear denunciation of authoritarianism and government overreach. As someone whose job it is to enforce and uphold the very authority the film critiques, his post demonstrates either a profound misunderstanding of its message or a willful disregard for it.
People should not be afraid of their governments. Governments should be afraid of their people.
And it's hard to ignore the absurdity of an officer who represents state power, while championing a film about fighting that same power. But this isn't an isolated case. It reflects a disturbing trend in law enforcement where officers, while representing the system, loudly complain about government overreach, conveniently ignoring the fact that they are the ones enforcing it. As a matter of fact, it isn't just irony, it's intellectual laziness, and shows a disconnect between those tasked with upholding the law and the principles they're supposed to defend. But as always, I'm more interested in what you think, and would appreciate reading about your ideas and concerns in the comment section. While this wasn't the video TRCU sent me to review, I greatly appreciate his efforts and channel, and his links will be listed below. Let him know I sent you, and if you liked this presentation, check out another episode using the links on screen.
Words will always retain their power. Words offer the means to meaning, and for those who will listen, the enunciation of truth. And the truth is, there is something terribly wrong with this country, isn't there?